Dear listener, if you settle into your bed tonight, let the soft weight of your blankets embrace you like a gentle medieval cloak. Take a deep breath, feeling the cool air fill your lungs, and allow your shoulders to sink deeper into your pillow. Tonight, we journey together into one of history's most peculiar and fascinating chapters, a time when the line between human and animal justice blurred in ways that seem almost dreamlike to us now. Close your eyes and imagine, if you will, the soft glow of candlelight flickering against stone walls. Picture the gentle sound of church bells echoing across cobblestone streets, marking the passage of time in a world where justice moved at the pace of oxen pulling carts through muddy village roads. In this distant past, where every sunrise brought the crow of roosters and every sunset the lowing of cattle returning home, there existed a curious tradition that would seem impossible today. Animals, pigs, cows, horses, even tiny field mice were sometimes brought before courts of law, just as humans were. They were given trials, appointed lawyers, and faced judges who deliberated their fate with the same solemnity reserved for human criminals. This is the story of those forgotten courtrooms where the squeal of a pig might interrupt a prosecutor's closing argument, and where the evidence included hoofprints in the mud and torn clothing hanging from farm fences. Let your breathing slow now, matching the gentle rhythm of a medieval town settling into evening. Feel your body relax as we step back through the centuries, past the noise of modern life, past the Industrial Revolution, past the Renaissance, back to a time when the world moved more slowly, when justice was a ceremony as elaborate as any church service, and when even the humblest barnyard animal might find itself at the center of a legal drama. The gentle dawn of medieval justice. Picture, if you can, a misty morning in the year 1386, in the small Norman town of Falaise, France. The sun rises slowly over thatched roofs and stone chimneys, casting long shadows across the town square. The air is cool and clean, carrying the scent of fresh bread from the baker's ovens and the earthy smell of animals stirring in their pens. Church bells ring out across the countryside, their bronze voices calling the faithful to morning prayers. In this peaceful scene, something extraordinary is about to unfold. A pig, a common barnyard sow, will soon stand trial for the murder of a human child. But this morning, as the town slowly awakens, the pig is simply another animal in the courthouse stable, perhaps rooting through straw, unaware that she will soon become the center of one of history's most unusual legal proceedings. The medieval world was built on order and ritual. Every aspect of life, from the grandest royal ceremony to the simplest daily task, was governed by traditions that had been passed down through generations. These were people who believed deeply in the importance of proper procedure, of following the correct steps, of ensuring that justice was not only done, but seen to be done. When a crime was committed, it required a response, regardless of whether the perpetrator walked on 2 legs or 4. In this orderly world, the courtroom was a sacred space. The wooden benches, worn smooth by countless bodies, were arranged with careful precision. The judge's chair, elevated above the rest, was carved with symbols of justice and authority. Sunlight filtered through tall windows, casting geometric patterns on the stone floor, where defendants, both human and animal, would stand to hear their fate. The scribes who recorded these proceedings wrote with careful flowing script on parchment made from sheepskin. Their ink, made from oak galls and iron, would stain their fingers a deep brown black. They recorded every detail with meticulous care: the date, the weather, the names of all present, and yes, even the description of the animal defendant. A pig might be described as brown and spotted, of medium size, with a torn left ear, as if she were a human criminal whose identifying marks needed to be noted for posterity. The town crier would announce the trial with his clear, carrying voice, walking through the streets, ringing his bell. Hear ye, hear ye. He would call, let all who seek justice gather at the courthouse at the hour of noon, and they would come, farmers in their rough wool tunics, merchants in their finer cloth, children peeking around their parents' legs, all drawn by the spectacle of an animal standing trial. The Sow of Falaise, a case study in medieval justice. The case of the Sow of Falaise remains one of the most thoroughly documented animal trials in medieval history. As you continue to breathe deeply and let your mind wander through these ancient halls of justice, picture the scene as it might have unfolded on that autumn day in 1386. The Sow had been accused of killing and partially devouring a young child. In our modern world, we might see this as a tragic accident, perhaps the result of negligence or misfortune. But in the medieval mind, this was a crime that demanded justice. The pig had broken the most sacred law, the taking of human life, and must face the consequences. The trial began, as all trials did, with the calling of the court to order. The judge, wearing his formal robes of office, took his place at the bench. The prosecutor, a learned man versed in both civil and canon law, presented his case with the same gravity he would use for any human defendant. The evidence was laid out methodically: the child's body, found in the pig's pen, the torn clothing, the witness testimonies of neighbors who had heard screams. But here's where the story becomes truly remarkable. The sow was not simply condemned without representation. She was appointed a lawyer, a real licensed attorney who took his duties seriously. This defense counsel examined the evidence, cross-examined witnesses, and presented arguments on behalf of his porcine client. Imagine the surreal scene: a learned man in robes, speaking eloquently about the nature of pig behavior, the circumstances of the alleged crime, and the legal precedents that might apply. The trial lasted several days. Each morning, the townspeople would gather in the courtroom, filling the wooden benches with the rustling of wool and linen. The sow herself was present for the proceedings, perhaps tied to a post, occasionally grunting or snuffling, oblivious to the legal drama playing out around her. The sound of her breathing, the shuffle of her hooves on the stone floor, the occasional squeal, all became part of the court record. Witnesses were called and sworn in. They testified about what they had seen and heard, their voices echoing in the high-ceilinged courtroom. The prosecutor painted a picture of a vicious attack, while the defense counsel argued for mitigating circumstances. Perhaps the child had provoked the pig. Perhaps the pig had been defending her young. Perhaps this was simply the natural behavior of an animal that could not be held to human standards of morality. The judge deliberated carefully, consulting legal texts and precedents. This was not a frivolous proceeding or a mockery of justice. It was a serious attempt to apply the law fairly and completely. The medieval legal system was built on the principle that all wrongs must be addressed, all crimes must be punished, and all defendants, even four-legged ones, must receive due process. In the end, the Sow was found guilty and sentenced to death, but even in her execution, the forms of justice were observed. She was hanged in the town square, but not before being dressed in human clothing, a bizarre but telling detail that spoke to the medieval understanding of justice as a human institution being extended to the animal kingdom. The execution was carried out with the same solemnity as any human hanging. The executioner, a skilled craftsman in his grim trade, performed his duty with professional precision. The crowd watched in silence, understanding that they were witnessing not just the death of an animal, but the completion of a legal process that affirmed their community's commitment to justice and order. The philosophy behind the madness. As you lie there in the comfort of your bed, you might wonder what drove medieval people to such elaborate lengths to try animals as if they were human criminals. The answer lies in the very foundations of their worldview, in beliefs about justice, responsibility, and the divine order that governed all creation. Medieval society was built on the concept of the great chain of being, a hierarchy that placed God at the top, followed by angels, then humans, then animals, and finally, inanimate objects. But this hierarchy came with responsibilities. Every being in the chain was accountable for its actions, and justice required that all wrongdoing be addressed, regardless of the perpetrator's place in the cosmic order. The idea that animals could be held legally responsible for their actions was not seen as absurd or primitive. It was viewed as a natural extension of divine justice. If God had given animals the ability to act, to choose between different behaviors, then they must also bear responsibility for those choices. A pig that killed a child was not just following instinct, it was making a choice that violated the divine order. This belief was reinforced by religious teachings that emphasized the moral significance of all actions. The Bible spoke of God's covenant with all living creatures, and medieval theologians argued that this covenant came with obligations. Animals, like humans, were part of God's creation and thus subject to God's law. When they violated that law, they must face earthly justice as a prelude to divine judgment. The legal scholars of the time developed elaborate theories to support animal trials. They argued that animals possessed a form of reason, not the sophisticated reasoning of humans, but a simpler form that allowed them to distinguish between right and wrong. A horse that kicked its master was not acting on pure instinct, but was choosing to rebel against rightful authority. A pig that attacked a child was not simply being aggressive, but was violating the fundamental law that protected human life. These theories were not just abstract philosophical constructs. They had practical implications for how society functioned. In a world where animals provided labor, food, and companionship, their behavior had to be regulated. Animal trials served as a form of social control, a way of reinforcing the boundaries between acceptable and unacceptable behavior for all members of society, human and animal alike. The trials also served a psychological function. When a child was killed by a pig, the community needed a way to process their grief and anger. Simply slaughtering the animal might provide emotional satisfaction, but it would not address the deeper need for justice. By putting the pig on trial, the community could channel their emotions into a structured legal process that affirmed their values and restored their sense of order. The elaborate nature of these trials, the appointment of lawyers, the careful examination of evidence, the formal pronouncement of sentence, all served to legitimize the proceedings. If the community was going to take the life of an animal, they needed to feel that they were doing so justly, in accordance with law and divine will. The trial process provided that legitimacy, transforming what might otherwise be seen as arbitrary violence into a solemn act of justice. The peaceful rituals of medieval courts. Let your mind drift now to the quiet details of these ancient courtrooms, the small rituals and procedures that gave structure to these remarkable proceedings. Picture the soft morning light filtering through tall windows, casting long rectangles of golden sunlight across the stone floor. The light moves slowly as the hours pass, marking time in a world where clocks were rare and the sun's position was the most reliable timekeeper. The court clerk, a learned man who could read and write in both Latin and the local vernacular, would arrive early each morning to prepare for the day's proceedings. He would arrange his writing materials with careful precision, sheets of parchment, quill pens cut from goose feathers, pots of ink, and small pouches of sand for blotting. His desk, made of heavy oak and scarred by years of use, would be positioned where the light was best for writing. The bailiff, responsible for maintaining order in the courtroom, would check the restraints used for animal defendants. These were not cruel devices, but practical necessities, sturdy ropes and posts that would keep a pig or cow from wandering during the proceedings. The bailiff took pride in his work, ensuring that everything was secure but not unnecessarily harsh. Even an animal deserved to be treated with dignity during its trial. As the morning progressed, the courtroom would slowly fill with spectators. They came not as bloodthirsty crowds seeking entertainment, but as members of a community witnessing the administration of justice. Farmers would sit beside merchants, craftsmen next to nobles, all united in their shared investment in the legal process. Children would be hushed by their parents, taught to respect the solemnity of the proceedings. The sound of voices would create a gentle murmur that filled the high-ceilinged room. Conversations were conducted in low tones, out of respect for the court and the seriousness of the occasion. The wooden benches would creak softly as people settled into their seats, and the rustle of clothing would create a subtle symphony of community gathering. When the judge entered, the entire courtroom would rise in unison, their feet shuffling against the stone floor in a sound like gentle waves. The judge, wearing robes that had been carefully maintained and passed down through generations, would walk slowly to his elevated bench. His every movement was deliberate, designed to convey the gravity of his office and the importance of the proceedings. The opening of court was marked by traditional phrases spoken in Latin, the language of law and learning. Oyez, 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 the bailiff would call, his voice carrying clearly through the room. All persons having business before this honorable court, let them come forward, and they shall be heard. The familiar words provided comfort and continuity, linking each day's proceedings to centuries of legal tradition. The animal defendant would then be brought forward, whether it was a pig, a cow, a horse, or even a collection of smaller animals like rats or insects. The process was the same. The creature would be positioned in the designated area, usually in full view of the judge and jury. There was something almost ceremonial about this moment, the formal presentation of the accused to the court of justice. The charges would be read aloud in a clear, carrying voice. Every detail was included: the date and time of the alleged offense, the names of victims and witnesses, the specific laws that had been violated. The reading was methodical and thorough, ensuring that everyone present understood exactly what the animal was accused of doing. Then came the appointment of counsel. The judge would formally assign a lawyer to represent the animal defendant, just as would be done for any human accused of a crime. This was not a pro forma gesture but a serious responsibility. The appointed lawyer would accept the assignment with the same gravity he would show for any client, human or animal. The extraordinary case of the ecclesiastical rats. As you continue to drift towards sleep, let me share with you one of the most remarkable animal trials in medieval history, a case that perfectly illustrates the elaborate lengths to which medieval justice would go to ensure fair treatment for all defendants, no matter how small or numerous. In the year 1522, in the French diocese of Autun, the local farmers faced a devastating problem. Rats had invaded their fields in enormous numbers, destroying crops and threatening the community's food supply. The damage was so severe that the local authorities decided to take legal action, not against the farmers for failing to control the pests, but against the rats themselves. The case was brought before the ecclesiastical court, which had jurisdiction over matters involving God's creatures. When the rats were formally charged with trespassing and destruction of property. 2. But here's where the story becomes truly extraordinary. Because the defendants were so numerous and impossible to gather in one place, the court had to develop creative solutions to ensure due process. 3. The rats were assigned a lawyer, a skilled advocate named Bartholomew Chassenet, who would later become famous for his legal writings. The 4. Chassenet took his responsibilities seriously, despite the unusual nature of his clients. 5. He appeared in court on the appointed day, ready to defend the rats against the charges brought by the farmers. When the court convened and the rats failed to appear, the prosecutor argued that their absence demonstrated contempt for the legal process, but Chassenet was ready with a response that would have done credit to any human defense attorney. He argued that his clients had not received proper notice of the proceedings. 6. The court summons had been read aloud in the local church, but rats could not understand human language. How could they be expected to appear in court if they had not been properly notified? The judge, taking this argument seriously, ordered that the summons be read in the fields where the rats lived. Town criers went out to the countryside and formally called upon the rats to appear in court, just as they would for any human defendant. The process was repeated several times, with increasingly urgent language, warning the rats that failure to appear would result in judgment by default. When the rats still failed to appear, Chassenet presented another argument. He claimed that his clients were elderly and infirm, scattered across a wide area, and therefore unable to travel to the courthouse. Moreover, he argued, the rats feared for their safety. The local cats, he pointed out, were natural enemies of rats and would likely attack them if they attempted to make the journey to court. The judge was persuaded by these arguments and granted several postponements, each time ordering that better provisions be made for the rats' safety. The case dragged on for months, with Chassenet presenting increasingly creative legal arguments on behalf of his absent clients. He cited precedents from Roman law, canon law, and local statutes, building a comprehensive defense that treated the rats as seriously as any human defendants. The case became famous throughout France, not as a mockery of justice, but as an example of how thoroughly the legal system would go to ensure fair treatment for all. Legal scholars traveled from distant universities to observe the proceedings, taking notes that would later be incorporated into their own writings on jurisprudence. The rats trial highlighted one of the most interesting aspects of medieval animal law, the question of collective responsibility. Since the rats were too numerous to be individually identified and tried, The court had to grapple with the concept of trying an entire species. This raised profound questions about the nature of guilt and innocence, individual versus collective responsibility, and the limits of legal authority. Chassigny argued that not all rats were guilty of the crimes charged. Some were too young to have participated in the destruction of crops. Others lived in areas far from the affected fields. Still others might have been sick or injured and unable to participate in the alleged crimes. How could the court punish all rats for the actions of some? The prosecutor countered that the rats had acted as a collective, coordinated in their destruction of the farmers' crops. They had shared information about the best fields to attack, had worked together to overcome the farmers' defenses, and had divided the spoils of their raids. If they could act collectively in committing crimes, they could be held collectively responsible for their actions. The judge found himself in the position of making fundamental decisions about the nature of justice itself. Could punishment be collective? Could an entire species be held responsible for the actions of its members? How could the court balance the needs of human society against the rights of animals to live according to their nature? These questions were not merely academic. They had practical implications for how society would deal with animal pests, natural disasters, and other challenges that threatened human welfare. The rat's trial became a testing ground for legal theories that would influence jurisprudence for centuries to come. The quiet dignity of animal defendants. As you sink deeper into the comfort of your bed, let your imagination carry you to those peaceful courtrooms where animal defendants face their accusers with whatever dignity their nature allowed. There was something almost poetic about these scenes, the formal majesty of human justice confronting the simple reality of animal existence. Picture a cow standing in a medieval courtroom, her large brown eyes reflecting the candlelight, her breathing slow and steady as the legal proceedings unfold around her. She doesn't understand the charges being read against her, doesn't comprehend the elaborate arguments being made on her behalf, but she stands there with the patience that is natural to her kind. The rustle of her movement, the soft sound of her hooves on the stone floor, the occasional lowing that interrupts the prosecutor's speech, all become part of the court record. The scribes who recorded these trials wrote with remarkable attention to detail. They noted not just the legal arguments and evidence, but also the behavior of the animal defendants. A pig's refusal to stand still during the reading of charges, a horse's nervous whinnying when the courtroom filled with spectators, a rooster's crow that coincidentally marked the moment when the judge announced his verdict. These details were not included for comic effect or to mock the proceedings. They were part of the official record because medieval justice demanded completeness. If an animal was to be tried as a responsible being, then every aspect of its behavior during the trial was potentially relevant to the case. The way a cow held her head, the alertness in a pig's eyes, the nervous pawing of a horse, all might be interpreted as evidence of guilt or innocence, awareness or ignorance. The lawyers who defended these animals took their responsibilities seriously. They studied their clients' behavior, looking for signs that might support their defense arguments. A pig that seemed calm and docile during the trial might be portrayed as naturally gentle, unlikely to commit the violent acts charged against it. A horse that appeared nervous and agitated might be described as suffering from illness or mistreatment that contributed to its alleged crimes. The judges who presided over these trials brought the same careful attention to detail that they applied to human cases. They observed the animal defendants closely, noting their reactions to the proceedings. Did the animal seem to understand what was happening? Did it show signs of remorse or defiance? These observations would be factored into the final judgment, just as a human defendant's demeanor might influence sentencing. The spectators, who filled the courtroom benches, also played their part in these dramas. They provided the community context that gave meaning to the proceedings. Their presence transformed what might otherwise be a bizarre spectacle into a serious communal ritual. They were witnesses not just to the trial, but to their society's commitment to justice and order. Children who attended these trials with their parents learned important lessons about responsibility and consequence. They saw that all actions, whether by humans or animals, had potential consequences. They learned that society took seriously its obligation to protect the innocent and punish the guilty. They absorbed the idea that justice was not just about punishment, but about maintaining the proper order of the world. The trials also served an educational function for the broader community. They provided opportunities for legal scholars to explain complex principles of law to ordinary citizens. The appointed lawyers would often use these cases to demonstrate various legal concepts, turning the courtroom into a classroom where the principles of justice were made visible and comprehensible. The ceremonial execution of justice. When an animal was found guilty and sentenced to death, the execution was carried out with the same ceremonial precision that marked every aspect of medieval justice. Let your mind drift to these solemn scenes where the forms of law were observed, even in the taking of an animal's life. The condemned animal would be prepared for execution according to strict protocols. In some cases, as with the famous sow of Falaise, the animal would be dressed in human clothing, a practice that might seem bizarre to modern eyes, but made perfect sense within the medieval understanding of justice. If the animal was being executed for human crimes, it should face death in human form, symbolically acknowledging the gravity of its offense. The execution itself was typically carried out in the town square, in full view of the community. This public nature was essential to the medieval concept of justice. The community needed to witness the completion of the legal process, to see that justice had been done and that the proper order had been restored. The execution was not entertainment, but a solemn civic duty. The executioner, a skilled professional who took pride in his work, would prepare for the task with the same care he showed for human executions. His tools would be clean and sharp, his technique precise and efficient. There was no cruelty in this process, no desire to cause unnecessary suffering. The goal was to complete the sentence of the court as quickly and humanely as possible. A priest would often be present to offer prayers and ensure that the proper spiritual protocols were observed. Even in the execution of an animal, medieval society recognized the need for divine blessing and spiritual guidance. The priest's presence transformed the execution from a simple killing into a sacred ritual, an act of divine justice carried out by human hands. The crowd that gathered to witness these executions was typically solemn and respectful. They understood that they were witnessing not just the death of an animal, but the completion of a legal process that affirmed their community's values. The execution marked the end of a disruption to the social order and the restoration of proper relations between humans and animals. In some cases, the executed animal's body would be displayed as a warning to other animals, a practice that might seem absurd to modern minds, but reflected the medieval belief that animals could learn from the consequences faced by their fellows. The sight of an executed pig or cow was intended to remind other animals of the importance of proper behavior and the consequences of transgressing human law. The legal fees and court costs associated with these trials were carefully recorded and paid, just as they would be for any human case. The lawyers received their compensation, the court officials were paid their wages, and the executioner received his fee. This financial aspect of the trials reinforced their legitimacy. They were not theatrical performances, but genuine legal proceedings with real economic consequences. The records of these executions were preserved in the court archives, along with all the other documents from the trial. These records served as precedents for future cases. Legal scholars would study them to understand how similar situations should be handled. The death of a single pig or cow thus became part of the evolving body of jurisprudence that would guide future generations. The gentle rhythms of medieval life. As you continue to relax into the peaceful embrace of sleep, let your mind wander through the gentle rhythms of medieval life that provided the backdrop for these extraordinary trials. Picture the slow, steady pace of a world governed by the sun's movement and the changing seasons, where the passage of time was marked by church bells and the natural cycles of agricultural life. The morning would begin before dawn, with the first church bell calling the faithful to prayer. The sound would echo across the countryside, reaching every farm and village, every manor house and cottage. People would rise from their beds, dress in the dim light of candles or oil lamps, and begin their daily tasks. The animals, too, would stir with the dawn, cows lowing to be milked, pigs grunting in their pens, horses nickering for their morning feed. The courthouse where these trials took place was typically located in the heart of the town, within easy walking distance of the church, the market square, and the homes of the local officials. It was a substantial building, built of stone or timber, designed to impress visitors with its solidity and permanence. The large wooden doors would be opened each morning by the court clerk, who would sweep the floors and prepare the room for the day's proceedings. The lawyers who participated in these trials lived comfortable lives, supported by their legal practice and respected by their communities. They were educated men who had studied at universities, learned in Latin, and familiar with the complex body of law that governed medieval society. Their libraries contained leather-bound volumes of legal texts, carefully copied by hand and preserved for generations. When not engaged in animal trials, these lawyers handled the full range of legal matters that arose in medieval society. They drew up contracts for marriages and business partnerships, settled disputes over property boundaries, and represented clients in cases involving debt, theft, and violence. The animal trials were just one part of their broader practice, unusual but not unprecedented in a legal system that sought to address all forms of wrongdoing. The judges who presided over these trials were typically appointed by the local lord or elected by the community. They were men of substance and reputation, trusted to make fair decisions and uphold the law. Their training was practical rather than theoretical. They learned by watching experienced judges and gradually taking on more responsibility as they gained experience and wisdom. The courtroom itself was designed to inspire respect and awe. The high ceiling, supported by heavy wooden beams, created a sense of grandeur and permanence. The judge's bench was elevated above the rest of the room, symbolizing his authority and the elevated nature of justice. The walls might be decorated with religious images or symbols of royal authority, reminding all present that earthly justice was part of a divine order. The wooden benches where spectators sat were arranged in orderly rows, each carefully positioned to provide a clear view of the proceedings. The wood was smoothed by generations of use, polished by the clothing of countless people who had come to witness justice being done. The floor was swept clean each day, and fresh rushes might be scattered to absorb moisture and provide a pleasant scent. The windows of the courthouse were positioned to provide natural light throughout the day, reducing the need for expensive candles or oil lamps. The glass was typically clear but might include colored panels that cast beautiful patterns of light across the room. The changing quality of light throughout the day marked the passage of time and added to the solemn atmosphere of the proceedings. The wisdom of simple farmers. Let your mind drift now to the simple farmers who often found themselves at the center of these animal trials, not as learned legal scholars or skilled advocates, but as ordinary people trying to make sense of extraordinary circumstances. Their wisdom, born of long experience with animals and deep understanding of rural life, often provided crucial insights into the cases being tried. Picture an elderly farmer, his hands gnarled from decades of work, his face weathered by sun and wind, standing in a medieval courtroom to testify about the behavior of the accused pig. He speaks slowly, choosing his words carefully, describing what he saw with the precision of someone who has spent his life observing animals. His testimony is not dramatic or eloquent, but it carries the weight of authentic experience. These farmers understood animals in ways that urban lawyers and judges sometimes could not. They knew the difference between a pig that was naturally aggressive and one that was acting defensively. They could read the signs of illness or injury that might explain unusual behavior. They understood the rhythms of animal life, the patterns of feeding and sleeping, the social hierarchies that governed barnyard politics. When a cow was accused of killing a child, the local farmers would be called to testify about the animal's history and character. They would describe how the cow had behaved in the past, whether it had shown signs of aggression, whether it had been properly cared for and fed. Their testimony was crucial to determining whether the cow's actions were the result of natural animal instincts or something more sinister. The farmer's knowledge extended beyond individual animals to entire species. They understood that certain animals were more likely to be dangerous at certain times of year, that breeding season might make normally docile creatures aggressive, that hunger or thirst could drive animals to desperate acts. This knowledge was essential to the court's ability to make fair judgments about animal behavior. Many of these farmers had been caring for animals their entire lives, having learned the skills from their parents and grandparents. They knew which animals could be trusted and which required careful watching. They understood the subtle signs that might indicate an animal was becoming dangerous. The way a pig's ears might flatten against its head, the way a cow's tail might twitch in warning, the way a horse's eyes might show the whites when it was frightened or angry. The farmer's testimony was often the most compelling evidence presented in these trials. While lawyers might argue about legal precedents and judges might deliberate about philosophical questions, the farmers provided concrete, practical information about what had actually happened. Their words carried the authority of experience and the credibility of people who had no reason to lie. These simple farmers also served as a bridge between the formal legal process and the everyday reality of rural life. They helped the court understand not just what had happened, but why it had happened and what it meant for the broader community. Their presence in the courtroom reminded everyone that these trials were not abstract legal exercises, but real events with real consequences for real people. The farmer's wisdom was often expressed in simple, homely metaphors that made complex legal concepts accessible to ordinary people. They might compare a pig's behavior to that of a spoiled child, or describe a cow's actions in terms of maternal instinct. These comparisons help the court understand the animal's motivations and make more informed decisions about guilt and punishment. After the trials concluded, it was often the farmers who had to deal with the practical consequences. If an animal was executed, they might be responsible for disposing of the body. If an animal was exiled, they might need to ensure it was properly removed from the community. If an animal was pardoned, they might need to take extra precautions to prevent future incidents. The sacred and the mundane. As you sink deeper into peaceful sleep, let your mind wander through the intricate ways that medieval society wove together the sacred and the mundane, the spiritual and the practical. These animal trials were perfect examples of this integration, combining religious beliefs, legal principles, and everyday concerns into elaborate ceremonies of justice. The medieval world was deeply religious, and every aspect of life was understood to have spiritual significance. When an animal committed a crime, it was not just a violation of human law, but a disruption of the divine order. The trials served to restore that order, to bring the wayward creature back into proper relationship with both human society and divine will. Prayers were an integral part of these proceedings. The court would begin each day with a prayer for wisdom and justice, asking for divine guidance in the difficult decisions that lay ahead. The lawyers would pray for eloquence and insight, that they might properly represent their clients and serve the cause of justice. The judges would pray for discernment, that they might see clearly through the evidence and arguments to the truth beneath. The church played a crucial role in these trials, providing both the theological framework that justified them and the practical support that made them possible. Priests would often be called upon to testify about the spiritual dimensions of the case, explaining how the animal's actions related to divine law and what forms of punishment or redemption might be appropriate. The concept of confession was sometimes applied to animal defendants, though obviously in a modified form. While animals could not literally confess their sins, their behavior during the trial might be interpreted as signs of remorse or defiance. A pig that seemed calm and docile might be viewed as showing proper repentance, while one that struggled and squealed might be seen as remaining rebellious against rightful authority. The question of animal souls was a matter of ongoing theological debate that directly influenced these trials. If animals had souls, then they could be held morally responsible for their actions. If they did not, then the trials might be seen as meaningless exercises. Different theologians reached different conclusions, but the general consensus was that animals possessed some form of spiritual essence that made them capable of both good and evil. The rituals surrounding these trials were designed to invoke divine blessing and protection. Holy water might be sprinkled in the courtroom before proceedings began. Relics of saints might be displayed to ensure divine favor. The judge's oath of office would invoke God's name and ask for divine guidance in the administration of justice. The medieval understanding of justice was deeply influenced by biblical concepts of law and punishment. The Old Testament provided numerous examples of divine justice being applied to both humans and animals. The story of Balaam's ass who spoke to protest her master's actions was often cited as evidence that animals could be held accountable for their behavior. The concept of sanctuary also played a role in some animal trials. Just as human criminals might seek refuge in churches, animals might sometimes be granted sanctuary while their cases were being decided. This practice acknowledged the sacred nature of all life and the importance of providing protection for the innocent, even when that innocence was yet to be determined. The seasonal rhythms of the agricultural year also influenced these trials. Cases were often scheduled around the demands of farming, with trials taking place during the winter months when farmers had more time to attend court. The harvest season was generally avoided for major trials, as the community's attention was focused on gathering crops and preparing for winter. The integration of sacred and secular concerns was perhaps most evident in the way these trials balanced practical needs with spiritual principles. The community needed protection from dangerous animals, but they also needed to ensure that justice was done in a way that honored divine law. The trials provided a mechanism for achieving both goals simultaneously. The tender mercies of medieval justice. As you continue to rest in the gentle embrace of sleep, let me share with you some of the more merciful aspects of these medieval animal trials. For not all cases ended in execution, and the legal system provided numerous opportunities for clemency and redemption. Many animal defendants were acquitted after careful examination of the evidence. The legal system took seriously the principle that guilt must be proven beyond reasonable doubt, and this standard was applied to animal cases just as rigorously as to human ones. Defense lawyers would often successfully argue that the evidence was insufficient, that the animal was acting in self-defense, or that mitigating circumstances justified mercy. Young animals were often treated with special consideration, just as juvenile human offenders received different treatment from adults. A calf that had caused damage might be forgiven on account of its youth and inexperience. A puppy that had bitten someone might be sentenced to training rather than execution, on the theory that it could still learn proper behavior. Pregnant animals were almost always spared execution, reflecting the medieval reverence for maternal life and the innocence of unborn offspring. The trial would often be postponed until after the birth, and the mother's sentence might be reduced or commuted in light of her maternal responsibilities. This practice showed a sophisticated understanding of both justice and mercy. The concept of exile was frequently applied to animal defendants, particularly in cases where the animal's behavior was problematic but not necessarily criminal. A pig that had repeatedly broken into neighbors' gardens might be sentenced to banishment rather than death, removed from the community but allowed to live. This solution satisfied the need for justice while showing mercy to the animal. Some animals were sentenced to perform community service. In a sense, a strong ox that had caused damage might be required to work additional hours for the community, helping with public projects or assisting needy farmers. This form of punishment had the double benefit of providing restitution for the damage caused while allowing the animal to continue living and working. The intervention of noble patrons sometimes led to pardons for animal defendants. A lord might intercede on behalf of a valuable animal, offering to pay compensation to the victims in exchange for the animal's life. These interventions were not seen as corruption, but as legitimate exercises of noble privilege and Christian mercy. Religious festivals and holy days were traditional times for the granting of pardons and the commutation of sentences. Christmas, Easter, and other major celebrations were often marked by acts of mercy toward both human and animal prisoners. These pardons reflected the spiritual significance of the seasons and the Christian ideal of forgiveness. The possibility of redemption was always present in these trials. Animals that showed signs of rehabilitation or whose owners demonstrated better control might have their sentences reduced or suspended. The legal system recognized that punishment was not always the best solution, and that mercy might sometimes serve justice better than strict enforcement of the law. Community petitions sometimes led to mercy for popular animals. If a cow or pig was well regarded by the community, respected for its usefulness or gentle nature, local residents might petition the court for clemency. These petitions were taken seriously and often resulted in reduced sentences or alternative punishments. The role of character witnesses was important in these proceedings. Neighbors, farmers, and others who knew the animal would testify about its general behavior and disposition. A pig that had lived peacefully for years before the incident in question might receive a more lenient sentence based on its previously good character. The quiet wisdom of medieval lawyers. Let your mind drift now to the learned lawyers who defended these animal clients, men who combined legal scholarship with practical wisdom, theological understanding with courtroom skill. They were the unsung heroes of these trials, bringing dignity and professionalism to proceedings that might otherwise have been dismissed as mere spectacle. Picture Bartholomew Chassenet, the lawyer who defended the rats of Autun, working late into the night by candlelight, preparing his arguments with the same care he would show for any human client. His desk would be covered with legal texts, church law references, and precedents from similar cases. He would write and rewrite his arguments, seeking the perfect phrase that would capture the essence of his defense. These lawyers were not opportunists seeking easy cases or comic relief. They were serious scholars who understood that their work in defending animals was part of a larger project of developing comprehensive legal principles. Every case they handled contributed to the growing body of jurisprudence that would guide future generations of legal practitioners. The challenge of representing an animal client required creative thinking and innovative legal strategies. How do you cross-examine a pig? How do you present a cow's side of the story? How do you argue for the innocence of a client who cannot speak for itself? These lawyers developed sophisticated approaches to these challenges, drawing on their understanding of animal behavior, human psychology, and legal precedent. Many of these lawyers wrote extensively about their experiences, producing legal treatises that would influence jurisprudence for centuries. Their writings combined practical advice about handling animal cases with theoretical discussions about the nature of justice, responsibility, and the relationship between humans and animals. These texts became essential reading for law students and practicing attorneys. The lawyer's approach to animal cases was characterized by thoroughness and attention to detail. They would investigate the circumstances of the alleged crime as carefully as they would for any human case. They would interview witnesses, examine physical evidence, and research legal precedents. They would also study the animal defendant, observing its behavior and trying to understand its motivations. The courtroom techniques used by these lawyers were adapted to the unique circumstances of animal trials. They would speak directly to the animal defendant, even though it could not respond, as a way of demonstrating their commitment to proper representation. They would describe the animal's actions in terms that made them comprehensible to human judges and juries. The lawyers' arguments often focused on the fundamental question of animal responsibility. They would argue that animals lacked the reasoning capacity to form criminal intent, that they were acting on instinct rather than malice, that they could not be held to human standards of behavior. These arguments required sophisticated understanding of both law and philosophy. The success of these lawyers was measured not just in victories and defeats, but in the quality of their arguments and the advancement of legal principles. A lawyer who lost a case might still be praised for presenting innovative arguments or raising important questions about the nature of justice. The goal was not just to win, but to contribute to the development of legal thought. The relationship between these lawyers and their animal clients was complex and fascinating. While the animals could not communicate with their attorneys in the conventional sense, the lawyers developed a sense of responsibility and even affection for their non-human clients. They would speak of their duty to represent the animal's interests as seriously as they would for any human client. The fees charged by these lawyers were typically paid by the court or the community, recognizing that proper legal representation was essential to the functioning of the justice system. The lawyers were not getting rich from these cases, but they were making a living while contributing to the development of legal principles that would outlast their own careers. The gentle decline of animal trials. As you rest peacefully in the quiet of night, let your mind follow the gradual decline of animal trials, a process that unfolded slowly over centuries as the medieval worldview gave way to more modern understandings of justice and the nature of animal behavior. The Renaissance brought new ways of thinking about the relationship between humans and animals. Scholars began to study animal behavior more scientifically, developing theories about instinct and learning that made it harder to justify holding animals legally responsible for their actions. The rediscovery of classical texts provided alternative models for understanding law and justice. The Protestant Reformation also contributed to the decline of animal trials. Reformed theologians questioned many of the assumptions that had justified these proceedings, arguing that animals lacked souls and therefore could not be held morally responsible for their actions. The simplified theology of Protestantism had little room for the complex theological arguments that had supported animal trials. The growth of centralized government and professional legal systems made animal trials seem increasingly anachronistic. Royal courts and trained judges were less likely to take animal cases seriously than local magistrates and amateur jurists. The professionalization of law enforcement reduced the reliance on community-based justice systems that had fostered animal trials. The economic changes of the early modern period also played a role, as agriculture became more commercialized and animals were increasingly seen as economic resources rather than quasi-legal entities. The practical arguments for animal trials became less compelling. It made more sense to simply compensate victims for damages than to go through elaborate legal proceedings. The last recorded animal trial in France took place in 1750, when a female donkey was accused of bestiality alongside her human co-defendant. Remarkably, the donkey was acquitted while the human was sentenced to death, the court finding that the animal had been an unwilling participant in the crime. This case marked the end of a tradition that had lasted for nearly 5 centuries. The decline of animal trials was not sudden or dramatic. They simply became less common as the centuries passed, until they finally disappeared altogether. The last cases were often viewed as curiosities, even by contemporary observers, anachronistic survivals of a worldview that was rapidly becoming obsolete. The legal precedents established by animal trials did not disappear with the trials themselves. Many of the principles developed in these cases continued to influence legal thinking about responsibility, intent, and the relationship between law and nature. Modern environmental law, animal rights legislation, and even some aspects of criminal law can trace their origins to concepts first developed in medieval animal trials. The documents and records from these trials became objects of scholarly interest rather than practical legal resources. Historians, legal scholars, and anthropologists studied them to understand medieval society, legal development, and changing attitudes toward animals. The trials that had once been serious legal proceedings became windows into a vanished world. The memory of animal trials lived on in folklore and popular culture, often distorted but preserving some essence of the original tradition. Stories of pigs on trial and rats with lawyers became part of the collective memory of medieval strangeness, simplified and exaggerated but still recognizable as echoes of actual historical events. The buildings where these trials took place often survived long after the trials themselves had ended. Medieval courthouses continued to serve their communities, hosting more conventional legal proceedings, but retaining the architectural features that had once witnessed the trial of pigs and cows. These buildings became inadvertent monuments to a forgotten tradition. The lasting legacy of forgotten justice. As you prepare to drift into the deepest, most peaceful sleep, let your mind rest on the lasting legacy of these forgotten trials, the ways in which they continue to influence our understanding of justice, responsibility, and the complex relationship between humans and the natural world. The medieval animal trials may seem bizarre to modern eyes, but they reflected a worldview that took seriously the idea that all creatures were part of a moral universe. In an age when animals are often treated as mere commodities or resources, there is something almost admirable about a legal system that was willing to grant them the dignity of formal legal proceedings. The trials also demonstrated a commitment to due process that was remarkable for its time. The appointment of lawyers, the careful examination of evidence, the elaborate procedures designed to ensure fair treatment, all of these elements showed a legal system that was serious about protecting the rights of all defendants, regardless of species. The philosophical questions raised by these trials continue to be relevant today. As we grapple with questions about animal rights, environmental protection, and the moral status of non-human creatures, we can find surprising wisdom in the medieval approach to these issues. The lawyers who defended pigs and cows were pioneering questions that we are still trying to answer. The tradition of animal trials also highlights the importance of ritual and ceremony in the administration of justice. The elaborate procedures, the formal language, the solemn atmosphere, all serve to transform what might have been arbitrary acts of violence into legitimate expressions of community values. Modern legal systems have inherited this understanding of the importance of proper procedure. The decline of animal trials was part of a broader transformation in how humans understood their relationship with the natural world. The medieval view of animals as moral agents capable of sin and redemption gave way to a more scientific understanding of animal behavior. But perhaps we lost something important in that transition, a sense of moral relationship with the creatures that share our world. The records of these trials provide a unique window into medieval society, revealing not just legal practices, but social attitudes, religious beliefs, and daily life. They show us a world where the boundaries between human and animal, sacred and secular, formal and informal, were drawn differently than they are today. The courage and creativity of the lawyers who defended animal clients continue to inspire legal professionals today. Their willingness to take on seemingly impossible cases, to develop innovative arguments, and to uphold the principles of justice, even in unusual circumstances, provide models for contemporary advocates. The community aspects of these trials, the way they brought together farmers, merchants, nobles, and common people in a shared commitment to justice, offer insights into how legal systems can serve broader social functions. These trials were not just about punishment, but about community healing, social cohesion, and the affirmation of shared values. The theological dimensions of animal trials continue to resonate in contemporary debates about the moral status of animals. The medieval belief that animals possessed souls and could be held morally responsible for their actions finds echoes in modern animal rights philosophy and environmental ethics. Perhaps most importantly, the tradition of animal trials reminds us that justice is not a fixed concept, but an evolving practice. What seemed reasonable and necessary to medieval people strikes us as strange today, just as our own practices may seem bizarre to future generations. The trials teach us to be humble about our own assumptions and open to different ways of understanding right and wrong. The quiet end of evening. The quiet end of evening. And so, dear listener, as the bells of those distant medieval churches fade into the quiet of night, as the last candle gutters out in the ancient courthouse, as the final entries are made in the court records with their careful script and brown ink, we come to the end of our journey through this strange and wonderful world of animal trials. Picture now the courthouse at the end of a long day of proceedings. The wooden benches are empty, the judges have retired to their chambers, the lawyers have returned to their homes, the animal defendant has been led away, back to the stable or pen that serves as its prison. The courtroom is quiet, except for the soft sounds of the night, the rustle of mice in the walls, the distant hoot of an owl, the gentle creak of timber settling in the cooling air. The clerk, working by candlelight, completes the day's records with careful attention to detail. Every word of testimony, every legal argument, every judicial decision is preserved in flowing script on sheets of parchment that will survive for centuries. These documents will outlast the courthouse itself, outlast the people who created them, carrying forward the memory of a time when justice extended even to the humblest creatures. In the distance, the bells of the abbey ring out the hour, their bronze voices carrying across the sleeping countryside. The sound reaches farms and villages, manor houses and cottages, reminding all who hear it that order and justice watch over their sleep. The pigs in their pens, the cows in their stalls, the horses in their stables, all rest under the protection of laws that recognize their place in the great chain of being. The moon rises over the medieval landscape, casting silver light on cobblestone streets and thatched roofs. The night is peaceful, ordered, governed by the same principles of justice that ruled the daylight hours. In this world, every creature has its place, every action has its consequence, and justice extends its protective embrace over all of creation. As you drift deeper into sleep, let your mind rest with the knowledge that you have visited a world where justice was not merely a human invention, but a divine principle that touched every aspect of life. You have walked through courtrooms where pigs stood trial and rats had lawyers, where the forms of law were observed with ceremonial precision, where the community gathered to witness the careful weighing of evidence and the solemn pronouncement of judgment. This was a world that believed deeply in the importance of proper procedure, of giving every defendant, human or animal, the opportunity to be heard and fairly judged. It was a world that understood justice not as simple punishment, but as the restoration of proper order, the healing of community wounds, and the affirmation of shared values. The medieval people who created these trials were not primitive or superstitious. They were thoughtful, careful people who took seriously their responsibility to create and maintain a just society. They understood that justice could not be arbitrary or capricious, but must be grounded in law, informed by wisdom, and tempered by mercy. Their legacy lives on in our own legal systems, in our own struggles to balance justice and mercy, in our own efforts to create communities where all creatures are treated with dignity and respect. The courthouse where the pigs stood trial may have crumbled to dust, but the principles it represented continue to guide us in our search for justice and truth. So rest now, dear listener, in the quiet knowledge that you have touched something timeless and profound. You have walked with medieval farmers and learned lawyers, with patient judges and careful clerks, with communities that gathered to witness the solemn drama of justice being done. You have seen a world where even the humblest pig could have its day in court, where even the smallest mouse could claim the protection of the law. Let the gentle rhythms of that distant world carry you into peaceful sleep. Let the sound of church bells ringing across the countryside, the rustle of parchment in the clerk's hands, the soft breathing of animals in their stalls, let all these gentle sounds guide you into dreams of justice and mercy, of order and compassion, of a world where every creature was valued and every life was sacred. The medieval animal trials were more than just legal curiosities. They were expressions of a worldview that saw the divine in all creation, that insisted on justice for all creatures, that refused to accept that might makes right. They remind us that our relationship with the natural world is not just practical, but moral, not just economic, but spiritual. As you sleep, may you dream of that gentler world where justice wore robes of ceremony and spoke in the ancient language of law, where every creature had its place in the great chain of being, where the forms of civilization extended even to the barnyard and the forest. May you find in those dreams the wisdom to create a more just and compassionate world for all the creatures that share this earth with us. And when you wake, may you carry with you something of the medieval commitment to justice and order, something of their reverence for life and their belief in the importance of proper procedure. May you remember that every creature deserves dignity, every defendant deserves a fair hearing, and every community deserves the protection of just laws fairly applied. Good night, dear listener. Sleep well and dream of pig trials and learned lawyers, of patient judges and careful clerks, of a world where justice was more than just a word, but a living, breathing reality that touched every aspect of life. Dream of the courthouse at evening, quiet and peaceful, where justice kept watch over all creation as the medieval world settled into sleep. In the gentle darkness of night, in the quiet hours when the world rests, the memory of those ancient trials reminds us that justice is not a destination, but a journey, not a final achievement, but an ongoing commitment. The medieval people who put pigs on trial understood this truth, and their legacy continues to inspire all who seek to create a more just and compassionate world. Sleep now, and let your dreams be filled with the gentle wisdom of the past, the patient hope of the future, and the quiet confidence that justice, in its many forms, watches over us all.